Honorable Madam Kirstyn presiding. You may be seated. Can't read a damn thing in these. The case of Sara, aka Girl Colton. Thank you. What are the charges being discussed? Section 139 of the Criminal Code pertaining to obstruction of justice. Are all parties present?
Yes, Your Honor. I am Rhonda Smith, and I am acting on behalf of the Crown.
Yes, Your Honor, I am Katelyn, and we are acting on behalf of the defendant, Girl Colton, in this matter.
Okay, thank you very much. Looks like we can begin. Throughout these proceedings, you will act as the judges of fact, and I will act as the judge of the law. Although I may comment on evidence, you are the only judges of evidence. However, when I tell you what the law is, my view of the law must be accepted. There is a basic principle that is fundamental to your role as jurors. In this case, there is a requirement beyond a reasonable doubt. All right, the Crown can begin.
Your Honor, ladies and gentlemen of the jury, I am Rhonda Smith. I am 21 years old, and I am the best lawyer in Canada. I haven't lost a case. Oh, yeah, sorry. Anyways, as I was saying, the defendant has been charged with obstruction of justice in the Criminal Code,
Which is section 139, 1B.
which states that everyone who willfully attempts in any manner to obstruct the course of justice in a judicial proceeding by agreeing to indemnify a surety. The evidence that I will provide today shows the defendant access card was used in the evidence locker at the time that the evidence was stolen. And not only that, the text messages sent were saying, "Mission accomplished. No evidence left. I expect the deposit today." A witness saw the event take place. The witness saw the defendant leaving the workplace with the evidence box in her hands. We have bank receipts with the account movement. The accused received $10,000 in cash 2 hours after the evidence was missing from the locker room. The mental element in this case is the specific intent to obstruct justice and receive a fee from a surety. The mental evidence I present to you, ladies and gentlemen, and judge, you look beautiful today, will prove the mental element and also the actus reus, and the defendant should be guilty of the charge. Thank you.
For the defense?
Your Honor, ladies and the gentlemen of the jury, under the law, my client is presumed innocent until proven guilty. During this trial, you will hear no real evidence against my client. You will come to know the truth that Girl Colton did not walk into the evidence room and take a piece of evidence during an ongoing investigation. There is no evidence or surveillance footage that my client entered the room nor taken this said evidence, and there is no proof that Colton had destroyed the evidence. My client is not guilty.
Hello? I understand. This trial will not be easy, girl, but if you are under any duress, there is a possibility that this case can be thrown out. Were you in immediate threat of death or seriously bodily harm with a well-grounded fear that the threat would have been carried out with no safe escape route? Okay, so no then. This might be a little harder than you thought. See you in a few days.
We would like to call Evelyn to the stand, please.
Please be seated.
Please state your name for the record as well as your occupation.
Evelyn, I'm an officer.
Were you working there on May 22nd?
Yes, I was.
What were you doing that day?
I stayed late in my office because I had to finish some casework.
Can you describe what you saw on May 22nd, please?
I was in my office working, and I saw Girl Colton walking in the hallway towards the evidence locker. I was kind of surprised to see her at first because her shift ended a few hours ago, and she even came by my office to say goodbye. And then I saw her open the evidence locker room and leave the room with a box of evidence for an ongoing case.
Why didn't you stop her?
I thought maybe she came back to work and had permission to take the evidence.
How did you find out that she had no permission?
Well, I didn't at first because she's been a hardworking member of the team for so long that I didn't really question it. And also, she had full authority to take the box of evidence out of the locker room because she is the police captain.
Can you point to the individual that you saw stealing the evidence from the locker room?
Yes, I can.
No further questions, Your Honor.
When you were working late catching up on your work, were you tired?
Yes, I was tired, but I knew for sure that it was girl leaving the room.
How are you so certain that it was indeed girl who went into the evidence room if you were tired?
Only so many people have access to the evidence locker during ongoing investigations, and girl was one of those people.
So you allowed girl to take the evidence from the locker room during an ongoing investigation just because she had authority?
Yeah. She was my boss, and any action that she does, I respect her decision.
So do you agree that because you were tired, your mind was not 100% coherent?
Yes, but like I said before, girl was the one for sure who walked out of that evidence locker.
Evelyn, you may step down from the stand.
Your Honor, I'd like to call Girl Colton to the stand.
Please be seated.
Please state your name for the record.
Sara Colton.
Where do you work, Girl Colton?
I am the police captain at Peterborough Police Station.
Where were you on the night of May 22nd?
I was at work finishing up documents for an ongoing investigation.
Was there anyone else in the station with you at that given time?
Yes, a few of my coworkers were present. All of them were at their desk finishing up documents for the night.
Did you enter the evidence locker room that night?
Yes, I used my card to get into the locker to put the remaining evidence from my case for the day in holding before I left for the night.
Did you leave the evidence room empty-handed?
No, I was carrying a box of things from my desk about the investigation that I brought home to continue working on it.
Can I ask you what was inside the box?
Yes, it was some files about the investigation, as well as some personal belongings, which I was taking home with me.
But this box didn't contain any evidence from the evidence locker.
No, it didn't.
No further questions, Your Honor.
Do you ever lie, Miss Colton?
No.
Never ever? Not even to a kid?
Well, I have.
Oh, so it is something you do often. Are you happy with your paycheck as a policeman, Miss Colton?
Could be a little better, but I don't mind.
How could it be better?
I could buy more stuff for my kids, my husband, myself, maybe even pay off some debts.
It sounds like you need money. Miss Colton, do you often get paid for other jobs?
No, ma'am, only my salary from the police.
Don't call me ma'am. I'm 21. Anyways, why did you receive $10,000 on May 22nd if it was not your payday? Were you aware that the evidence box was stolen on May 22nd from the locker room?
I found out the next day when I got to work.
Did you really? Well, can you explain the following text messages for me? Mission accomplished. What mission were you talking about? There is no evidence left. Where? Where was no evidence left? I expect the deposit by 5 p.m. You owe me a big one after this. Would you mind, Miss Colton? What do those text messages mean?
I didn't send them.
You didn't send them? Well, Miss Colton, are you aware that we went through your phone the day you were arrested? Did you use the locker room on May 22nd?
I don't recall. It was too long ago.
Oh, she doesn't recall? All right, let me refresh your memory. On May 22nd, you used your access card at 5:36, which is 36 minutes after your shift was done, and you signed out at 5 p.m. All right. After you stole the evidence, you got in your car and sent the text messages saying that you expected a deposit, that the mission was accomplished, and that he owed you a big one, or she. Who knows? Is that enough to refresh your memory, Miss Colton?
All right, Miss Smith, I think we get your point, but I think we're going to take a quick recess and allow the jury to deliberate the facts of the case. This case is interesting, isn't it? Yeah, that's what I thought too when it first started. Obstruction of justice requires that the Crown prove the element of intent, aka the mens rea, which is very difficult to prove in cases such as these because most people won't admit to their crimes. This is a massive legal and evidentiary issue for the Crown, as lack of proof of mens rea will result in the accused being acquitted. One thing the Crown may be able to use as proof of the element of intent would be to have the police interview people close to the accused who may have heard them mention something about the act they committed. This would be helpful as it would provide knowledge that the accused was aware of the event prior to committing it, which proves that they intended to commit the act. Also, timestamps are very helpful in this case, as the key card of the accused helps to place the person at the scene at the specific time. When a prosecutor goes to fight an obstruction of justice battle in court, they need to be sure that they have a substantial amount of evidence to prove both actus reus and mens rea that hopefully will result in a conviction. But, yeah, I'll be back after lunch. Can't wait to scarf down that lasagna that I've been waiting for. Peace! Okay, the court is now in session. After hearing the remarks from both the Crown and the defense, I'm sure that the jury was able to come to a verdict.
Yes, Your Honor. We, the jury, find the accused guilty as charged. The evidence of the key card and the witness testimony left us no choice. There was sufficient evidence in this case to prove that the accused obstructed justice.
Alrighty, court adjourned.
I'm going to jail.